Yes.
Lordship, I beg to mention item number 8 today.
Hmm.
Yes, Lordship, I have been recently engaged in this matter,
Hmm.
filing my wakalatnama today, Lordship. Can it be on any other day, Lordship, in the next week or any day convenient for the court, Lordship?
Very limited case today.
I-
You're for the petitioner.
I'm engaged for the petitioner, Lordship.
Can't help it. Mr. R.K. Talukdar, Learned Counsel, R.K. D. Chori, sorry, Learned Counsel, submits that he has been engaged in this matter very recently, not very recently. Therefore, press for sometime. Press for adjournment. Mr. Which for a press comment? Lordship. Considering above, let this matter be listed after.
Lordship, any day convenient to the court, Lordship.
After three weeks.
May please, your lordship.
Yes.
I'm praying for a listing of a stay vacating application, my lord, on Monday, my lord. The interim order has been obtained by misleading this honorable court, my lord.
What is the urgency?
My lord, my financial power has been cut off, my lord. I am a democratically elected president of a Anchalik Panchayat, my lord. And the correct facts were not placed before your lordship, my lord. When the interim
Yes,
order
yes.
Monday, my lord. Deeply obliged, lordship.
May I please, Your Lordship? But for listing of a review petition, earlier the writ was disposed of on the very motion matter directing the state authorities matter to dispose of the representation of the matter petitioner, the writ petition matter. But here the case is matter the petitioner matter filed a writ petition suppressing the fact that the her husband matter had 2 more wives. So ultimately after death of the husband matter she filed a writ petition seeking family pension and retirement benefit, and that writ petition was disposed of directing the authorities to consider the representation matter. Now, since the other two petitioner, other two wives, they were not implicated as parties. So ultimately, after that, they file a new petition that is pending before this court. But at the same time, review petition also has been filed before this court, since the review that order was passed by your lordship, So, matter is very urgent. Otherwise, the family pension may be dispersed in favor of the earlier writ petitioner who
No, direction is for what?
for consideration of the representation.
So,
Now, the authorities may, change the present petitioners.
we have not directed to grant them the family pension to dispose of the representation.
Representation,
You file an objection there. You
already
also file a representation.
objection has been filed, but so far the information of my petitioner is concerned, instead of my petitioner is concerned that the authorities they are processing the family pension in favor of the petitioner. Since the other two petitioners before this court, in other writ petition, they are also wife of the deceased employee, but they are not implemented as parties in the writ petition. So, this review has been filed for dismissal of the review petition.
How many-
Writ petition.
Huh?
This review petition has been filed for dismissal of the writ petition that was disposed of earlier. Since that writ petition was filed, suppressing the material fact that the deceased employee had 2 more wives, and those 2 wives were not implicated as parties. They ought to have been implicated as the respondent in the writ petition, but that was not done, That was suppressed and the writ petition was filed and they took the order. Now, the respondent authorities, they are processing the family pension in favor of the writ petition.
We don't know. Direction was not to provide family pension
Yes,
for the
to consider
petitioner.
the representation, the writ petition was filed.
If you know that, you file an objection.
So, review petition is pending before this court, may be listed on Monday,
After a week, in that case. After a week.
in the next week,
Hmm? After a week. I don't know
Woodward matter is there. in
whether
supplement-
review lies or not.
In supplementary list, there is a Woodward matter,
Huh?
There is a Woodward matter in the
Let
supplementary
it
list.
come its own turn.
Mal.
You be there.
May I please, your lordship? My lord, I beg to mention for listing of a urgent motion item, my lord, tomorrow, my lord. It is a matter relates to eviction and demolition.
Hmm?
Matter of, relating to eviction, my lord, motion item, tomorrow, my lord.
We'll see.
Mal. Obliged, my lord, it is filing is going on, my lord. Some time for the number is required.
don't
sir.
know.
I'll give it, my lord.
If it is not within the time, we.
Yes,
we
sir.
will
Within
permit
time,
you to
I'll
list it,
try.
but if you could not file it,
My lord, my lord.
can't help it.
My lord, I will bring it within half an hour, my lord. Obliged, my lord.
Please, your lordship, by this mention memo, your lordship, I beg to mention attempt for listing on 3rd of December, your lordship.
Why?
This matter is pending, your lordship. The daughter of the petitioner is missing, your lordship. The police is not taking any action, your lordship. Notice was issued on lordship. 3rd of December, your lordship.
Why third of December?
Lordship,
Why third of December?
any date, your lordship, in the month of December.
Any fix? Whatever it is.
In the first week, if possible,
Hmm.
3rd. Oblige.
Lordship, with consent of other side, Lordship, I beg to mention item number 4, Lordship.
Hmm.
Respondent number 4, file their affidavit in opposition, Lordship. I want to file reply, Lordship, sometime maybe given, Lordship.
What is there?
I'm for response number 4.
Anyway, on the prayer of Mr.
Islam, on behalf of B. Sinha.
S. Islam, learned counsel appearing on behalf of Mr. B. Sinha, learned counsel for the petition. List this matter after 3 weeks so as to enable him to file affidavit in reply.
Reply.
So as to enable the petitioners to file affidavit.
Oblige.
Yeah, please, also, there's a prayer for listing of a writ petition in regards to Panchayat election, your lordship. It has not been listed for last 3 months. So it may be taken up any
After 2 weeks.
next week.
After 2 weeks. Panchayat election is already over.
No, lordship, the
Long
election
time
is
back.
already over, but the oath ceremony is yet to be taken, your lordship.
Hmm?
Oath ceremony is yet to be done, and we are praying for interim in that case, and the matter is still to be heard.
What oath ceremony? I don't know.
Because the election that took place, their election.
When is supposed to be taken up? I mean, the oath ceremony was supposed to be after the election within?
Within a month, but it has not been, it not happened yet. And also the election that had happened, the voting that took place of the dead person also, and there are also persons who are staying abroad. So with that we have brought to the notice of the court. It's a completely unfair election that had happened. So we are praying for.
You are elected members.
Yes, so one of the elected members, we are against the elected members, we are the candidate in the particular voting. And
You
also,
were elected, you are a
no,
elected member.
I was not elected, I was a candidate where.
After 3 weeks. Why you, if you are not elected, what's the question of vote taking and all?
The other petitioners are also hearing who are their voters, independent voters in that case.
It's not a voter, it's the elected, so far as the vote taking is concerned. It is for the elected members, not the voters.
We are challenging the entire result here.
And there's no tribunal. Yes, Mr. Roy,
Yes, Lord.
there's no tribunal.
Yes, for election.
Election,
District judge, is.
No, Lordship, there is no tribunal in the district of Puja, Your Lordship. We have challenged that also. And that part also, they have been asked to give a notification, an affidavit in this regard.
so let
other
them
side.
give them affidavit.
And they have taken adjournment
When
of
is
the
this,
last date.
when is supposed to be listed?
It was supposed to be listed 3 months ago, Your Lordship. It was
Yes.
after 2 weeks. And it has not been listed now till today. And affidavit also not been filed yet. Yes.
After 2 weeks, Lordship, we will.
After 2 weeks.
Obliged.
Yeah, please, Your Lordship. Lordship, I am praying for listing one motion matter, face matter, Lordship. Lordship, there is life threat to me, Lordship, and accordingly I have, after obtaining training certificate, applied for arms license, Lordship. And as per the rules, Lordship, concerned licensing authority has to issue within 30 days of receipt of the police report, Lordship.
Next week.
And since, Lordship, Monday, Lordship.
Hmm.
Obligement.
May I please, Lordship? Lordship, I beg to mention for listing of a writ petition, my lord.
Ah.
Matters relating to, my lord, no confidence motion of municipal board, my lord.
2 weeks.
My lord, can it be fixed on first week of December,
2
my lord?
weeks. We'll see.
May please, Lordship, I have to mention for listing of withdrawal, my lord, this red petition, my lord.
What about withdrawal proposals? Mr. So-and-so, learned counsel for the petitioner. Petitioner submits that he may be allowed to withdraw this petition. Mr. SS Roy, learned state counsel and MS. correspondents are present. Accordingly, writ petition stands dismissed on withdrawal.
My lord, actually, the petitioner want to avail civil remedies before the civil court, my lord, only for,
Nobody is stopping.
my lord. My lord, with liberties, my lord, to approach any other court, my lord, civil court, my lord.
It's okay. Nobody will stop. There's no bar.
At least, my lord, they may take the plea, my lord, they may take the plea, my lord.
And then
Yes.
you write with the liberty to approach the, to avail the appropriate remedy.
Yes,
List of next paragraph. This, it's on withdrawal with the liberty as spread. Ah.
I love it.
Yes, yes, sir.
Lordships,
When did you travel to come?
Part Lordships.
When did you travel to come over here? No, when?
When?
You would have come?
Yeah, day before yesterday, Lordships.
Ah, yes.
And the privilege to address Lordships for the first time. Now, Lordships, this matter pertains to eviction that the state is undertaking in a place called Lutumari Reserve Forest. This is the second time we are approaching Lordships. The eviction notice Lordship will find at page 36, annexure 2.
That's okay.
Yes.
So what is why you have annexed this status quo order by the Honorable Supreme Court?
Because now the order that has been passed, which is impugned before your Lordships, relies on the division bench judgment of this court, which is now a subject matter of challenge in the Supreme Court, whether Supreme Court has ordered status quo, only to that extent.
We'll say status quo in view of the,
Pardon me.
we'll, in the interim, we'll issue notice.
Yes,
And in the interim, we'll say that in view of the
yes, sir.
subject matter, all the same petitioners.
Yes, that's all.
No. Different. The different.
No. The eviction notice, those were different petitioners, but the process is same.
Same area. Same area.
Different. Area is also different.
Area is different. But the procedure that has been adopted, the division bench laid down a procedure. Because admittedly, there is no procedure which the state also admits before the division bench, with judgment also we have annexed, that there is no laid down procedure for evicting these people in case it is found that they are illegal encroachers into the land. So the division bench said, earlier you used to give 15 days, but you give them 15 days extra. And and also in the division bench judgment, there are certain observations. Now the whole judgment is now in challenge.
That judgment.
That judgment.
And in that judgment, the writ petitioners were not the party.
We were not parties.
So based on that, entire things were taken up.
Yes, even in this.
Including where the present petitioners was also issued
Yes,
notice.
because in fact, the present notice also refers to these two judgments only. If Lordship will see the order impugned before your
Now
Lordship.
that judgment is a subject matter before the Supreme Court.
Yes. And the order that we have impugned.
Supreme Court has passed to maintain status quo.
Status quo.
So according to you,
We
And-
could also be, because because if Lordship will see the impugned order, for a moment, Lordships, the impugned order is at page 99. And please come straight to page 100. Page 100, now therefore, if I may just read from there. Now therefore, after due consideration and in exercise of powers conferred under section so and so of the Assam Forest Regulations 1891, read with the directions of the Honorable Guwahati High Court in writ appeal 251 2025 and 252 2025, order dated so and so, it is hereby ordered that. So the state relies on these orders, which are now subject matter of challenge, and the Supreme Court has ordered status quo.
29.
Yes. And that order is also, Lordships, we have annexed the writ appeal order, which is
Madam,
that.
I have serious objection to that, madam, because after the Honorable Supreme Court's order, in fact, madam, that is an order to maintain status quo among the parties in that case, madam, in that proceeding. I will kindly see the last page, and I will also take note of the date of the Supreme Court's order, madam. pending disposal of the special leave petition, the parties shall maintain status quo. Parties to that proceeding, my lord. Then, my lord, will see the date when the order was passed, my lord. It was 22/8/2025. 22/8/2025, this order was passed. In thereafter, my lord, these same petitioners approached this honorable court. If my lord failed at page 75, this same argument was made, which was negated, my lord, because that status, that is not a absolute interim order, it's a status quo order among the parties.
May I place my?
Let me
case, Lordship?
complete, my lord. Let my.
I have not even completed, Lordship, but asked me a query about the Supreme Court order. I have responded to that.
Just page 75 for a moment, my lord.
Just wait, just wait.
Lordship had inquired why have we annexed this order, so I have adverted to that. I have not been placed my case.
Page 75, my lord, the same petitioners approached earlier, my lord, after the Supreme Court order, status quo order. They placed that status quo order, it was not accepted.
Where is the non-acceptance?
Non-acceptance means, my lord, there is no reference to the Supreme Court order. If-
Out of the blue.
That was annexed to the earlier writ petition, my lord.
These are arguments across the bar being made.
I think, my lord, I should address your lordship, not to my friend, my lord. Page 93 is the order, my lord. The same petitioner, my lord, obtained this order from this honorable court after the Supreme Court order. Supreme Court order is of 22/8, page 93, my lord will see identical petition, all the petitioners are same. It is dated 6/11/2025, page 93, my lord. 2 months, 3 months after the Supreme Court order, they approached. In that petition, my lord, the Supreme Court order was also annexed. Then, my lord, this order came to be passed. My lord will kindly see page 97, my lord, is the operative portion. 97 operative portion, paragraph 12, my lord. Sri so-and-so, learned so-and-so has submitted that the remaining petitioners can be allowed to submit their representations within a period of 7 days from today. That is up to 13/11/25 before the respondent number 4. This court is of the view that the remaining petitioners who have not yet filed their representations shall be allowed to file their representations on or before 13/11/2025. It is ordered accordingly. Then paragraph 14, my lord will see, it is observed that if the representations is received from any of the noticee or petitioner herein by the respondent number 4, the respondent number 4 shall examine the representations and the supporting documents in justification of the parcels of the land he/she is in occupation. The order so passed by the respondent number 4 shall be communicated to the petitioner representationist forthwith. Thereafter, the respondent number 4 shall examine whether the parcels of land under the occupation of the noticee petitioner falls inside or outside the boundaries of Lutumari Reserve Forest declared by notification dated 7/8/1982. It is further observed that if any parcel of land under the occupation of the noticee petitioner is found outside the boundaries of the Lutumari Reserve Forest, no eviction exercise as contemplated in the notice dated 8/10/2025 shall be undertaken by the respondent number 4. It is further observed that if the parcel of the land under occupation of the noticee are found inside the boundaries of Lutumari Reserve Forest, then the respondent number 4 shall carry out the exercise to clear the Lutumari Reserve Forest areas in accordance with the law and as per the due procedure. They were happy with this order, my lord. They submitted representations. Now we have verified and found that they are inside forest. So the order impugned has been issued. This proceeding also the Honorable Supreme Court order was placed. Since it was an order among the parties to maintain status quo in that proceeding, my lord, that's a different reserve forest. So we are allowed to proceed by this Honorable Court itself. So, my lord, it is too late in the day for them to say that because of the Supreme Court order, they are protected. That endeavor they already made. In fact, my lord, in the meantime, a PIL was also filed. Wherein also, my lord, the Honorable Supreme Court orders was placed. But this Honorable Court in the division bench, my lord, clearly held that the earlier this writ appeal order, my lord, which they are saying it is pending for Supreme Court now, that was directed to be followed, even after status quo order by the Honorable Supreme Court. Meaning thereby, my lord, it was accepted by the Honorable Court that the status quo order will be applicable only to those petitioners. There is no stay of that judgment, my lord. Only the parties are directed to maintain status quo.
But then your order, page 99,
My lord.
it based on the order of the pursuant to the
Yes,
division
writ
bench judgment.
Yes, that division bench judgment, my lord, there is an order to maintain status quo among parties. And that division bench, after the Supreme Court order, there are 10 to 20 orders of this Honorable Court, final disposal order, when this was directed to be followed, my lord. This writ appeal 251 up to 725. So that interim order, status quo order, has no application to this petition. These are different for us, my lord. We are following the guidelines of the division bench, my lord. That is all. But rest, my lord, the facts are absolutely different. Different reserve forest, admitted position, they are inside forest, my lord. There are other judgments that they should immediately be evicted, my lord. So they submitted representation. I have maps to indicate, my lord, entire area comes within the boundary of the reserve forest.
Okay, that is, we have understood. But the problem is, if you have relied on decided on the basis of the direction of the division bench,
My lord,
which is subject matter of the Supreme
Supreme
Court,
Court,
when there is a status to be maintained, right?
my lord,
The order which the has been passed
pass, my lord,
has been pushed to challenge, passed pursuant to the division bench
division bench
order.
order.
You have not done it independently.
Yes, but that is, we are following the division bench judgment order, my lord, because there are other orders of this honorable court wherein, my lord, we are directed to follow that judgment in spite of the status quo order of the honorable Supreme Court, my lord. That is what I am submitting. In spite of the Supreme Court order, my lord, of status quo.
Where does it say, where does it, any mention?
Right now, I have one. If my lord, in fact, peruses the order, earlier order of these petitioners, my lord, page 98, that is why I was indicating, my lord, the date. And in fact, that in that writ petition also, page 98,
No, is there any mention of the status quo that passed by the Supreme Court?
my lord, that is
Is
not
this judgment-
specifically mentioned, but my lord will kindly appreciate, my lord, this is an order passed after the status quo order. In that writ petition, my lord, they themselves annex the Supreme Court order, my lord.
We don't know
They have annexed, my lord.
where it is. Is there any reference or made by the court in this?
Court has not
25
specifically
order?
said, my lord, but there is one more division bench order, my lord, of my lord. That is our court of Virginia. Page 21 of that bunch of documents, my lord. My lord will also see herein also, my lord. Page, this is a PIL, my lord. Page
This is
20.
of which place?
If this PIL pertains to all the evictions undertaken in Assam, my lord. This PIL was dismissed finally, my lord. They challenged all the. So my lord will also see herein also, my lord, the date, page 23, my lord will see. Date is 9/10/2020, sorry, 10/9/2025. After the Honorable Supreme Court status quo order, then this Honorable Court, my lord, holding the PIL not to be maintainable. Also, my lord, recorded paragraph 7, my lord, page 27. The learned Advocate General further submits that the so and so has not made any statement that unauthorized so and so by indigenous people of a particular religion without the consideration, would not be considered as an engrossment. The learned AG further submits that concession given by him in the order dated 18/8/2025 passed in writ appeal number 215 of 25 would also be applicable in this case. Finally, my lord will see that paragraph 12, my lord. Paragraph 12, the issue of eviction. Paragraph 12, my lord, page 28. The issue of eviction in the present case is with respect to encroachment and unauthorized structures built within the reserve forest area. It has nothing to do with the persons having any criminal cases against them. Be that as it may be, in a similar case pertaining to the same reserve forest, a coordinate bench had abide order dated so and so, same writ appeal, my lord, by holding that if a drive for clearing reserve forest areas of all encroachment was undertaken, and if it was found that there was some unauthorized settlers, they ought to be given a reasonable time of 15 days to explain under what circumstances they had set up their residence inside the forest area where any non-forest activity or their presence attracted penal offense. They were then to given a further 15 days thereafter for vacating the place. If they were found to be encroachers, the coordinate bench further held that the same would, however, not protect the encroachers from being prosecuted for any offense committed by them for carrying out non-forest activity inside reserve forest area under Regulation 24/25 of Assam Forest Regulation. Then the relevant paragraph of that writ appeal, my lord, quoted, my lord, paragraph 13. Then finally, my lord, paragraph 15, my lord, will see, noticing the fact that we find that the present PL is not maintainable, we have the view that as a similar issue had been decided by the coordinate bench of this court in writ appeal so and so, the directions passed in that case also be applied to unauthorized settlers and encroachers who are to be given out from reserve forest areas after they are given a so-called notice of exile.
That's what I'm trying to say.
Yes. So, my lord, consistently, my lord, despite there being a status quo order by the Supreme Court, consistently this honorable court by honorable single benches and division benches passed this order, my lord, to follow writ appeal.
No. Writ appeal has been followed.
My lord.
writ appeal, order of the writ appeal has been followed,
Yes, my lord.
including in this PL.
Yes, my lord.
And in the other cases where the petition has been disposed of,
Yes, there are, my lord.
cases of the petitioner
Yes,
by the coordinate bench.
My lord.
Doesn't they speak about the status quo order passed by the Supreme Court
but
in
because,
that case? Because basically what it is to be seen is consistently, as you said,
my lord,
it has to be the order of the division bench
My lord.
in
Writ
Writ
appeal.
Appeal 251 has to be followed.
my lord,
That has been put to challenge.
my lord,
Obviously not by the petitioner,
my lord,
but the petitioners daring.
my lord.
And in that case, the Supreme Court has directed to
True.
maintain status
Well,
to the parties.
To the parties, that has been, my lord.
But then if, and at the same time, when you have said that you have taken a decision, whatever action, of course, as per the writ appeal,
My lord.
251, and it has been put to challenge. So
My-
if for a time being, since the
Because-
direction has been in terms of the pursuant to the writ appeal
My
or
lord,
the division bench,
My
which
lord.
is the subject matter before the Supreme Court,
true, my lord.
including the
True.
the
That is true.
PL, which
That
has
is
been
true. That is true. But my lord will kindly appreciate one thing, my lord. That status quo, that is not a stay of the division bench order. That is an order to maintain self, because in the meantime, that if a forest, my lord, everyone were
There's
evicted.
no question of
That
stay.
is not stay, my
You
lord.
have already taken
My lord,
the actions in terms of the division bench order,
my lord,
right?
right.
That you have already taken.
Taken, my lord.
Whether it is properly in accordance with that or whether in accordance with law, we'll examine that.
No,
But
that,
today,
what I'm submitting, my
today
lord.
when the basis of the order which you have passed,
My lord.
that is the division bench order
Order
in
is-
WA 251.
Is it before Supreme Court now?
Supreme Court.
True,
When
my
there is a men- to
But my lord will
maintain
kindly
status
appreciate, my
quo,
lord, after the Supreme Court status quo order, there are several orders, my lord, not one, two, my lord, 10, 20, 30 orders.
Nobody has, there's nothing has been referred.
Everybody, my lord, referred to, may not be recorded in the order. My lord will kindly do one thing.
Unless it is not recorded.
My lord will
I
kindly do one thing.
understand.
My lord will kindly do one thing. This eviction,
I'm not saying that this is automatically apply.
everybody argued.
This
no,
is,
Court, though not recorded, my
this
lord.
is akin to, I mean, order in personnel,
Exactly,
according to you.
exactly.
Now, since that has not been referred or considered by any of the orders,
My-
either by the division bench or the coordinate bench, we cannot presume that it
Because,
was
my lord,
placed and
For that,
considered.
for that presumption, my lord, may I pray, my lord?
Yes.
Since my lord, till 29, nothing will happen. They have been allowed time till 29. My lord will fix it on tomorrow, clubbing the earlier repetition. It is annexed in the, that Supreme Court order was annexed.
It's not a question of
It
annex.
was annexed, it was
See,
argued.
ultimately, the petitioners annex so many documents.
My lord,
We just take the relevant documents.
my lord.
And I'm not saying that your action is illegal.
True. My lord,
The
will- my lord will kindly appreciate.
problem today at present is for the interim protection and in view of the fact that the similar matters is sub judice before the Honorable Supreme
My
Court.
lord kindly appreciate one thing, my lord. In that case, my lord, we have
And
what we are following.
there's a orders recently also by the Honorable Supreme Court that when the matter is under consideration by the Supreme Court, we normally should not,
Should not.
High Court should
But
not.
here is a case, my lord, kindly appreciate, my
determine.
lord. That was the status quo among the parties, not before these parties, my lord. Not, it is not.
I
There
understand.
is no stay of the division bench order.
I know.
There are 10, 20 orders, my lord.
It's very clear. That's what I'm saying, sir.
I got it.
There's no reference.
It has no
to
reference.
this. Today we'll refer it.
My lord will do one thing, my lord. We'll post it tomorrow, my
Yeah,
lord.
even I am not, we may not grant pass the interim order.
My
Not
lord,
because we find prime facie illegal or not in accordance with law by by you. Order may be correct.
my lord will post it tomorrow, my lord. I will try to bring all the orders filed by the Honorable Court, my lord.
Yes, give him a chance because I'm inclined to pass the interim order because of the.
My lord will post it tomorrow, my lord. I will try to bring all the orders, and my lord also, my lord will
Yes, sir.
direct the registry to my lord post the.
Prima facie, I'm inclined to
got it,
grant
madam.
interim, but then let us hear it because
But because
I'm
it will
not
have,
on the prima facie, I mean, the case on merit of the case. Only because of the connected matter being before the Honorable Supreme Court.
yes,
Therefore, I am,
I
I'm
will
of the
post it
prima
tomorrow,
facie
my
view
lord,
that
because if
we'll
they are
have-
allowed to stay till
we have
29,
to
30.
direct to maintain status quo.
Not today, my lord, pass it tomorrow. My lord will pass it tomorrow, my lord, because they are allowed to
Nothing
stay
is
there
going to-
till 29, my lord. The same order can be passed by tomorrow also, my lord. For my satisfaction, my lord, let me submit everything before.
We have
your lord.
directed them to.
He may
vacate
submit
by
everything,
29.
Lordship, he may submit everything, but we would also like to have a look.
Yes,
Just
we'll give them a copy, my lord.
No, that you have not, so therefore Lordships will keep, let this interim order be a limited interim order. You fix a date.
Tomorrow, my lord, without status quo, my lord will pass the same order tomorrow, my lord.
You will hear him tomorrow.
Because, my lord, this
Because
will have
prima facie,
severe
I find
ramification,
that
my lord.
Interim order is called for just only because.
Got it, my lord.
subject
Absolutely,
matter
absolutely.
is pending before the Honorable Supreme. Court.
Absolutely, my lord. My lord will post it tomorrow, my lord. Or if I cannot satisfy your lordship, my lord,
It's not that I may not.
if I am not being,
grant interim relief also.
my lord, if I am
But
not,
I just, if he's
Yes.
taking time, so it's, you
Tomorrow,
have
my
been
lord.
directed to vacate by 29,
after 29, my lord.
after 29.
Tomorrow is 28, my lord. My lord will not pass any order.
Consider.
Tomorrow, my lord, if I am not able to satisfy your lordship, my lord. will pass it.
Otherwise, he'll curse me.
My lord, only one request, my lord. This case, my lord, 6-90-25, earlier repetition may be called, my lord.
Simply so, any order by the coordinate bench where this order of the status quo passed by the Supreme Court is
I will
referred,
try, my lord. I will try.
right?
My lord.
We'll consider everything.
6-90-2025.
Because I have,
And sir, this is a forest land.
Absolutely
No, no,
forest.
It
Right, sir.
appears to be prima facie, it's
No,
a
no.
forest land.
no, therefore that is the whole case. That is the whole case. If you Lordship will see a prayer, what are we seeking? We are just seeking a joint verification. Please do it.
That has been done, my lord.
That has not been done. The
I have
problem
reports
is that.
that
They
that
have
we-
the- Sir, joint verification had been done by the departments
Yes,
Yes.
not with us.
in the absence of the petitioner.
That's it. That
My
is
lord,
our
we have-
case.
My lord, we have the
Lordship
map,
has hit the
geo
bullseye.
coordinates, my lord,
The
include,
Lordship
my lord,
has hit the bullseye.
if we, my lord, give
That is
them
all.
everything
If that is your only claim, we can dispose of the writ petition also.
Yes.
Yes.
to
please.
make a, to,
Think about it.
my lord, if my lord is.
With
interested-
us, with us.
What do you mean by principle of natural? Finding an opportunity.
That can be done, because my lord, earlier,
not
my lord, if I have understood correctly, my lord, earlier order was to, my lord, consider a representation, it was done absolutely without hearing them.
Yes.
That can be, that order can be passed, we will not go for eviction unless they are personally heard.
We'll hear it
Stay,
tomorrow.
my lord, any stay,
We may dispose of the matter tomorrow.
tomorrow, my lord, tomorrow.
Yes, sir. Such time, let it not be.
That could be that your.
Yes, because all that we are seeking is this.
That is fair, my lord. I will,
That is our prayer also. Lordship.
Yes, we'll consider.
yeah, that aspect may also be kept open, my lord. I will try to satisfy first, my lord, or
Ah.
else, that is
You
agreement.
think about this aspect also.
My lord, I always say, my lord,
Admittedly, there's no, I mean, the verification was in their absence,
exactly.
right?
We'll make them a party to the verification process again.
Joint verification
My
means
lord,
what?
though, my lord, I am absolutely, my lord, against enforcement, my lord, but everything should be done in human way, my lord. That I have said.
Nobody is for enforcement, Lordships. We also would like the forest
Well,
lands to
in
be
their
clear.
petition, my lord, they have written admittedly that we are inside forest, declare a village. Inside a forest, they want a village, my lord. That's a page 90.
We will,
their
leave-
own document.
we will remain, save our energy for tomorrow.
Tomorrow,
Lordships.
my lord. Deeply obliged, my lord.
Just one request, Lordships. Can this matter be taken up a little higher on the board because I may have to, second up, I may have a.
No, Saturday, Sunday, you enjoy Guwahati.
No,
He has
yes,
to leave.
no, there
He
is
has
a
to leave
issue.
for Delhi
No,
tomorrow.
I have to go, not for enjoyment, Lordship. Day after tomorrow, our school alumni meeting is there in Delhi.
That is also part of enjoyment, my lord.
Therefore, I have to, if Lordship can just take it up a little
Let
higher.
us see.
That's my only request, Lordship.
If there is urgent matters, I mean, more urgent matters, then we'll take it up. We'll see.
Well, I am so very grateful.
Deeply obliged, my lord.
Very.
Deeply obliged.
No.
Heard Mr. Goswami, huh?
I'm so sorry.
T.N. Goswami,
Manish
recently.
Goswami, Senior Counsel assisted by
Mr. PM Decker.
for the petitioner.
T.N. Goswami, my lord, recently.
Mr.
T.N. Goswami.
No, on the prayer of Mr. P.N. Goswami, learned additional advocate general appearing for the states, let this matter be the state tomorrow, i.e. 28/11/2025.
Publish.
Again tomorrow. Okay, we'll see.
Deeply. Well.
Huh? It's not necessary, we'll go by the whatever is there.
I'm extra copy will do.
Yes, all this additional advocate general.
Lordship, Mr. D.P. Bora is appearing in this matter. He is
No,
on.
all this additional advocate general also.
Right.
You are for the petitioner.
Yes, Lordship.
Why did not approach the consumer?
Lordship.
Why did not approach the
Because there
consumer
was
court
earlier
about it?
order from
Criminal
the
courts.
Honorable Division Bench of this High Court
Hmm.
for paying compensation to other victims.
That is
So
something different.
during that time only, these petitioners, they also suffered from eye loss. So they approached this Honorable Court.
Yes, this matter,
My lord.
compensation. Admittedly, the petitioners, they have lost their eyes.
Okay.
And there is a report that there is no negligence. However, the committee has suggested for certain compensation.
Okay.
Do you have the report?
The report, yes, we received it from them, the last occasion, Lordship.
Yes.
But they have also passed, they have filed an affidavit in opposition wherein the inquiry report was annexed.
Hmm.
Although they have not admitted to any negligence on part of the
Yes,
doctors,
that is
but
what
there
I'm-
were some recommendations to be
No,
done.
if you agree, the lump sum amounts they have calculated,
Lordship,
4 lakhs each,
Lordship.
because admittedly, then we may dispose of the petition
Lordship.
if you agree. Otherwise, normally if you claims, I mean,
Higher.
higher amount and all, you'll have to approach the
Civil court.
civil court or the consumer,
Lordship.
provided if it is easier taken.
To quantify the damage or loss.
Yes,
basically.
yes. Do you agree?
Lordship.
5 lakh ka kora. Fine, okay.
So in view of this
Yes.
report and all, we'll direct them to
Yes.
pay within a month.
My lord.
They have
Yes.
lost their eyes.
Yes, my lord. Definitely.
Very unfortunate.
Lordship.
God forbid, such things doesn't happen. Of course, there's no finding with regard to the negligence.
Yes.
There's no negligence. All right,
Lordship.
just we'll dispose of the
Got-
matter together. We'll direct you to pay the
My lord.
amount computed by the committee.
My lord.
Huh? All right. Who is for you are for health department.
Yes, Lordship, Mr. D.P. Bora is appearing in this matter. He is on legs before the division bench one, Lordship. So,
Hmm.
His name may also be recorded, my lord, no problem.
You just inform.
Lordship.
Because there's a finding of there's a report by the committee. By the medical expert, right? Not Mr.
D. Decker.
Land Council for the petitioner. And Mr. P.N. Goswami. Learned Additional Advocate General for the State, Assam, and Mr. D.P. Bora. Learned Standing Council, Health and Family Welfare Department. The respondents, huh? What? Next bit. These repetitions are have been filed. Seeking monetary compensation to the petitioner alleging gross negligence by the treating doctors. Right. Well, undertaking the eye operation. At which hospital?
It's BP Civil Hospital, Nagaon,
BP Civil Hospital. It's a government hospital.
Lordship.
BP Civil Hospital, Noga, which is, within bracket, which is a government hospital. Huh? Under the state of Assam, bracket close. Considering, next one, huh? Having considered that these writ petitions, the issue involving these writ petitions is similar on the facts and law. Same are taken up and disposed of by the present, by this judgment. Huh? Next paragraph. The petitioners hailing from an economical backward strata of the society were suffering from the eye ailment of cataract. This stuff, being the economically backward and underprivileged, they got themselves admitted in the BP hospital, Nagaon, a hospital under the state of Assam. This stuff. The doctors and the hospital, BP Civil Hospital, undertaken a cataract surgery on the following dates, huh? They have given the dates, huh? 7/3/2017, 10/3/2017. Check out from that, huh? Other petition. And were discharged. Not following, where you just give only on 7/3/2017, 10/3/2017, so and so, huh? And were discharged on different dates, particularly, so and so that, these five. Next paragraph. It is the contention of the petitioner that after the cataract surgery, or the petitioner operation and discharge, huh? After cataract operation and discharge from the said civil hospital, they were confronted with severe irritation in their eyes, which were operated. Thereafter, they were taken to the said hospital by their friends and relatives. On examination by the treating doctor, it was informed that the cataract surgery, which was undertaken, were improperly done. Accordingly, the petitioners were referred to Sri Sankardeva Lateral, wherein they were evacuated. They had to pass to Guwahati. Sankardeva Natural Guwahati, huh? Which they had to rush to the Guwahati. Mr. At second, they were natural at Guwahati. On examination, it further came to light that the catering operation so undertaken upon the petitioners by the doctors of said civil hospital was not properly conducted, and to prevent further damage, it was advised that the affected eye, upon the affected eye, a further surgery will be conducted for removal to prevent further deterioration. Thereafter, the petitioners on different dates had undergone surgery at Sri Sankan Deva Natural Hospital, Guwahati. And has to, for removal of the affected eyes, it is the contention of the petitioner that the petitioner had to lose one eye each without on their part. Mr. Under the circumstances, the petitioner contends that, no, please, under the circumstances, the petitioner claims for monetary compensation. Please, where is the affidavit? Under the public law remedy, huh? Please, where is the affidavit? Have you gone through it?
Affidavit is filed by DHS on 31/5/2024.
Where it is?
Part of the report. Filed in WPC 863 of 2020.
In which writ petition?
Hemoram Das, item number 2. (863) of 2020.
Hemaram Das.
Submit that in this case, Mr. D.P. Bora from the health department is appearing. He is some late note. Okay, Lord.
Nothing. the Director of Health Services, Government Basa, has placed the inquiry report which has been conducted. Inquiry report conducted with regard to the incidents of post-operative complication following pediatric operation. Pediatric surgery in Nagar Civil Hospital. Pertains to the petitioners. This stuff pertains to period from 07/03/2017 to 11/03/2017. Stuff. Which is placed on record by affidavit. This affidavit doesn't say anything.
Affidavit, like Lordship, at page 95, there is findings
Hmm.
where it was stated that the OT ceiling had signs of seepage.
Huh? 95.
Page 95, there is findings. In the OT inspection following were observed.
Hmm.
So, there was this, sign, the OT ceiling had signs of seepage. One steel sink is found in, which was used for both hand scrubbing and ceiling. So this was not in norms. Norms with the, how a OT room should be. Lordship.
We don't know the expert. Where is that? Is there any recommendation?
Recommendations at page 96, Lordship.
Hmm.
IoT at BP Civil of Nagaon is to remain closed till microbiological clearance is available and after fulfillment of the following recommendations.
Renovation improvement, IO for the. Yes, is it?
Wall tiles up to ceiling, wooden beads of ceiling to be replaced by plastic beads. OT roof tins to be replaced to prevent seepage. So,
Next paragraph. A perusal of the inquiry reports dated inquiry report indicates that out of the total 41 cases operated, about 13 persons had developed complications and were ultimately treated as Sri Shankar Deva Netralaya Guwahati under the national list of, huh? The findings indicate certain deficiencies in the hospital. So far as the pediatric in the operation theater list of and therefore the inquiry report, inquiry committee recommended that eye operation theater at BP Civil Hospital, Nava, is to remain closed till the microbiological clear is available and after fulfillment of renovation and improvement of the eye operation theater infrastructure, etc. Huh? So, the state response next panel. Biden. But communication dated 04/11/2025 from the Joint Secretary, by the Joint Secretary to the Government of Assam Health and Family Welfare Department, Dispur, to the Standing Council Health and Family Welfare Department. List. The computation of the compensation amount to be paid to the petitioners and or to the their legal heirs who allegedly who suffered visual complication following cataract surgery is conducted at Nava Civil Hospital, Nava, in connection with Nava, Mr. The report or computation of the compensation as placed by the state authorities indicates that the petitioners have suffered visual complication following cataract surgery at the said hospital. Some of whom have subsequently expired other ailment. Some of them have died.
Most of them, Lordship.
How many petitioners total?
Uh,
13?
No, out of 13, 7 petitioners are before your Lordship, in 3 writ petitions.
Huh?
7 patients have come before this honorable court in 3 writ petitions, Lordship.
Bristol. Ah. It also reflects that there is no negligence of the lapses on the part of the treating authority of the said hospital during the treatment of the patient. Mr. However, computed the compensation amount of rupees 4 lakh each, to the persons who have suffered visual complications following the cataract surgery at the said hospital. It also suggested for payment of compensation to the petitioners and or to their legal heirs who had suffered visual complications following the said cataract surgeries, including the petitioners herein. Mr. P.N. Goswami, next one, learned counsel for the petitioners, learned counsel, learned additional advocate general, and Mr. B.P. Bora. You tell him,
Yes,
inform him, and standing counsel. Health and Family Welfare Department, sir, have clearly submitted them. In terms of the recommendation of the committee computing the amount of compensation, the state is ready to pay the said compensation to all the persons, including the petitioners who have suffered eye complications following the cataract surgery, which was undertaken under the scheme. There's one scheme, is 95. Yes. Under the scheme, namely so and so. That's all. You pay all of them,
My lord.
either to the legal heirs, next time. It is noticed that some of the persons who have who had to the petitioner, the persons, including petitioners, have undergone such an ordeal wherein due to minor surgery, minor cataract surgery, able them had to lose their eye due to certain complications or deficiencies that had arisen during the course of the treatment, public surgery at the said EPCB hospital now. Although no finding is recorded with regard to the negligence on the part of treating doctor, facts remain that the patients, the persons who belongs to economically backward strata, who wish to avail the welfare scheme under the government, had to lose their precious eyes, which not only, which amounts to, which has violated the fundamental rights under Article 21 of the Constitution of India. Stuff. This code or would you like to pay more?
That instruction to I know. Since they themselves have
They
admitted,
have
my lord.
lost, and of course they have died in some other ailment. Just imagine the people.
Means, my lord, that is.
Anyway, leave it, next minute. Having considered that the petitioners, having considered that the state respondents have come forward to compensate the persons who have lost their eye following the cataract surgery. What I said, having considered the design. At civil hospital, at the state hospital, at the BP civil hospital, Nagaon, to compensate, even if no finding is recorded with regard to negligence on the part of treating doctor at the said hospital. But due to certain deficiencies in the operation, eye operation theater. And also considering that the and the considering the benevolently, benevolently, and considering that considering the fair submissions of learned court, the additional advocate general and the standing counsel part, as well as in view of the fact that the petitioners and the persons, 13 persons who have undergone cataract surgery have to lose their eye following the said surgery. I deem it appropriate to dispose of the said petitions with a direction to the responding authorities to make payment to all the affected, all the aggrieved persons, public or to their legal heirs, including the petitioners, a sum of rupees 4 lakh each within a time frame. Accordingly, it is directed that the responding authorities shall pay all the agreed persons, all the persons who have eye complications following the cataract surgery. Only persons, public or to their legal heirs, including the petitioners. 13 in numbers, 13 in numbers. All you pay all
Yes,
of
sir.
them.
Irrespective
whether
of
they
being
have been
petitioned.
court or not. Sum of rupees 4 lakhs so and so. In a period of 1 month. 1 month.
6 weeks, well, 6 weeks.
6 weeks. 6 weeks from today. It is made clear that the respondents authorities are to make payment to the persons who have suffered, irrespective of whether they have persons who have suffered, including in public legal heirs who have suffered so and so, irrespective of whether they have there before this or not, whether they have approached this court or not. That's a great petition is this person.
My lord. This is in RAM, my lord.
Hmm.
This order is in RAM, my lord,
Yes.
not in personam. Deep level,
13% only.
my lord.
Obliged, Lordship.
May I please, your lordship? Yes, your lordship directed that, lordship, I have obtained instruction.
No, I mean,
Right. Lordship, kindly period the last order of this honorable court, Lordship.
Yes, your lordship directed to obtain instruction, I have received,
even the instruction,
I have received instruction.
what is the instruction? What is the matter?
Matter relating to sealing land.
Huh?
Sealing land, acquisition of sealing land, Lordship.
Yes, this has been recorded as Sarkari in the year 1976.
That is, that is why, Lordship. After that, Lordship, a revision petition was filed.
Huh?
Revision petition was filed against the ceiling surplus. That revision was not dismissed, disposed. Subsequently, Lordship, this land is still under our possession. That revision petition, Lordship, was not allowed, disposed, subsequently filed a writ petition. Writ petition was disposed of, directing them to dispose of the revision petition.
Yes.
That revision petition, Lordship, has disposed of against, that is, I have annexed that order, Lordship, page 59. And against that, this writ petition is filed.
On what
My
ground?
lord, that is the wrong order because the land, Lordship, if your Lordship, and the predecessor of the petitioner, Lordship, had 93 biga of land prior to selling surplus. My lord, in 1969, 25 biga of lands, Lordship, were given to her, to his two sons in the year 1969. And that land was separately meted in their name. They were living separately. But while the Lordship selling was made in the year 1976, this 25 biga land was also included in that land. That is the case. That cannot be.
Recorded you in the year?
My lord, that land was made selling surplus in the year 1976.
Recorded
But-
and mutated in your favor? In favor of these two sons?
Two sons, yes, yes.
The year, when it?
69, 1969. 1969.
How do you?
That if your Lordship,
Resolve it?
my lord,
How do we resolve it?
yes, Lordship, that land cannot be, Lordship, included in the selling surplus.
What is the mutation?
Lordship, page 59, your Lordship may kindly come to the impugn order.
Anyway, first, page 59.
59. Their own individual Lordship, the land is still the possession of the present petitioner. They have not taken the land.
59.
59.
Now it is government land.
Lordship, may I read, Lordship?
Hmm.
Hearing was conducted on 31/8/2024 in the office chamber of the undersigned for disposal of the revenue petition bearing number so and so, sealing case number so and so. Since the case details of the revision petition, peruse the report submitted by the circle officer, Gosaigaon Revenue Circle, so and so, with regard to the case. Heard the parties Srimati Shefali Das and others, present petitioner, in charge of so and so Revenue Circle was also present. It was found that land measuring 92 biga 1 kata 9 lesa was recorded before the date of sealing case in the names. Your Lordship will see the important. Shuklal Das, the predecessor of the present petitioner.
No, it was found that land measuring 92 bighas.
Yes, was
That is
recorded
land-
before the date of sealing case in the names. The following manner, there, this 92 bigger lands were
Suklal.
recorded. Suklal Das, Kukibala Das, these two were lordship, the predecessor of the petitioner. Nitai Chandra Das and Gaur Chandra Das,
Hmm.
late Nitai Chandra, Gaur Chandra.
Hmm.
My lord, these two persons are the son of number 1 and 2, father and mother.
Who is Kukila Bala?
Yes, Suklal Das and Kukibala Das. And
Who is
detail,
Dital Das?
yes, lordship, now details of sealing surplus land measuring
Who is Dital, who is Sukilal Das?
mother of Nitai Chandra and Gaur Chandra.
Huh?
Namma Suklal Das is the father, was the father, and Kukibala Das, mother of
Nital Das and late.
Nitai Chandra Das and late Gaur Chandra Das.
Are the son of late Sukal Das.
Yes, Suklal Das. Details of sealing surplus land measuring 37 bigha. Lordship, this area of land was made sealing surplus. 37 bigha, 3 kata, 13 lesa out of the total land measuring 92 bigha, 1 kata, 9 lesa is shown below. This is important, your lordship will see.
Hmm.
Number 1, patta land measuring 7 bigha, 4 kata, 9 lesa recorded in the name of Suklal Das from 3 village so and so. And auxiliary so and so land and 3 bigha, 2 kata, 19 lesa respectively. And patta land measuring 4 bigha, 2 kata, 9 lesa recorded in the name of Kukibala Das. And this is important, lordship. Number 3, patta land measuring 25 bigha, 1 kata actually, lordship, wrongly written bigha. 15 lesa recorded in the name of Nitai Chandra Das and late Gaur Chandra Das. Both were son of Suklal Das from revenue village Blokkoti. The case is pertaining to this land. It is also seen that the following 3 plots of lands were recorded in the name of Suklal Das, and these were not considered in the sealing surplus. This area were number 1 land measuring 32 bigha, some lesa, and land bigha 3 bigha, 1 kata, 15 lesa, and another 18 bigha, 3 kata. These lands were not taken under sealing surplus. It was asked to the parties to submit their claim and objection. They stated that whatever records are available, these are in the case details. Details have been checked and informed to the parties. The claim of the petitioner that sealing was done wrongfully is incorrect due to the fact stated above, and therefore the revision petition hereby disposed of and the honorable court order dated is complied with.
Hmm.
My lord, this 25 bigha of land with 25 bigha, 1 kata and 15 lesa. This land was given lordship in the year 1969. That is, your lordship will find at page
What? How much? 20?
25 bigha, 1 kata.
One- Ah.
This land was lordship recorded in the name of this the 2 person Nitai Chandra and Gaur Chandra. That is, your lordship will find page 24.
Ah. But it's
7,
okay.
6,
Before
9,
that, whether it is recorded or not, saying that
my lord.
doesn't record, it is not recorded
It
here in the impute
this
order.
land, this 20 bigha land lordship.
Parcel land measuring 25 bighas so and so, recorded the name of so and so, were sons of so and so, Huh? Then
Now your lordship will come to page 24.
it's okay, they have said so.
So this area of land should not be lordship included in the sealing surplus land, because this land were totally independent land belonging to these 2 son of their ancestor lordship. And as per provisional lordship itself, if your lordship kindly go to
Parcel land
the
measuring so and so recorded, recorded in the name of Nital Chandra Das and late God Chandra Das. Both were sons of Shukla from revenue village, Block Kuti. It also seen following 3 plots of land were recorded in the name of Shukla. It was to the judgment of the claims of they stated that whatever records are available in the claim of the petition that the sealing case was done wrongfully is incorrect due to free that above Yes.
Matter, my lord, in this regard, instruction is very clear, my lord.
No, your order says something else.
In this regard also, I need to
I'll, I think it is required to
What?
file
Why?
affidavit. Affidavit is required. Lordship.
See, you have recorded that patta number, patta land measuring 25 so and so,
In the,
recorded in the name of so and so. Huh?
after that ceiling surplus in the year,
It doesn't say so, anything.
NX.
Then you said it was, they stated,
22.
checked and informed the claim of the petition. They
Yes.
stated that whatever records are available,
Yes,
these are in the case details. Details have been checked and informed to the parties. The claim of the petitioner that the sealing case was done wrongfully is incorrect due to the facts stated above. And therefore, what does it mean?
As per order dated 1976 in ceiling case number 97.
Is your instruction? From where you have not recorded in your order.
এটা দিবি আর আরেকটা আছে এটা দিবি
Is not it, Mr. Khan?
লর্ডশিপ
There's a finding that the 25 vigas has been recorded in the name of your predecessors.
yes absolutely
Sons,
every documents
sons
lordship
of two sons of late Suklal.
yes
Then how they said that it is, now why how they are saying that?
My lord, please come to.
This
Yes,
25 acre land cannot be included along with the land of Suklal Das and others.
That's 25?
Lordship
Yes,
pays
25.
Column lordship that as per order dated 9/9.
Page?
25.
Yes, number 25, lordship.
The order, as per the order, we cannot make out anything. Page 25.
This is the continuing page of 24. From-
24.
from-
Yes. As per order, there is an insulin bill of SDC bill order of the district collector, land of Suklal has been declared as ceiling surplus. Huh.
So that is the land of the predecessor of the present petitioner. That was
Ah.
that was the 25 acre land recorded lordship on 7/6/1969. Your lordship has seen. And in the next page 25, this is the record lordship regarding ceiling.
Hmm.
That was made on lordship 9/9/1976.
Ah.
So after that, after 7 or 8 years back, lordship, this land was made ceiling surplus, including the land of this 25 acre.
Mhm.
That land should not be included with the land of Suklal Das.
19 out of 92,
Yes,
25 has been made ceiling.
no, 37 bigha has been,
37 become.
including this 25. 37 bigha has been made ceiling surplus,
Ah.
including this 25 bigha of land.
How many you have now?
No, lordship, at present lordship, we are concerned only our 25 bigha of land. This 25
What
bigha,
about others?
others lordship were after 37 bigha lordship, if you lordship deduct 25 bigha, that remaining land will be the ceiling surplus land.
Hmm?
Will be the ceiling surplus land. That is lordship beyond the land of 50 bigha. And including forest and others lordship and gardens, so another 4 bigha can be added, so 54. At the time of
Yeah, once it has been made in 1976,
Yes.
how do we challenge it now?
no, that was the wrong entry in the wrong entry made in the ceiling surplus order, including they have included the land of 25 bigha.
What about the other land?
Lordship, other lands they
Out of 92,
lordship,
they have made 37.
37.
So out of 37, you are claiming that since this
25
has been
bigha.
mutated,
Yes, this 25 bigha of land, we are continuously possessing lordship. This land as per their
you
record,
are not claiming 37.
no, we are claiming only 25 bigha of land.
This has been made surplus in 1976.
Yes, that was the wrong, wrong order lordship there.
No,
No,
it's the office record.
this 25 bigha of land cannot be clubbed with the land of Suklal Das.
Huh?
They have lordship consider while the ceiling surplus was made, including the land of 25 bigha.
So what's the wrong in the order?
So this 25 bigha of land cannot be clubbed with the land of Suklal Das.
Huh?
Cannot be clubbed with the land of Suklal Das.
Doesn't say so. It said that it is mutated in the name of this, your predecessors, two persons, right?
My lord, as per provision lordship, if they are separately living and they will be the independent family.
How do you review of the order in, when it was made in 1976?
Lordship, their lordship kept the revision petition pending. Revision petition was made in the year 1978.
Hmm?
This revision petition was disposed of lordship with the intervention of this honorable court in the year 2024.
After this order is passed.
Lordship, let them lordship file a detailed affidavit on that. They have lordship submitted the incomplete
What is the
instruction.
provision? In
Lordship,
case if there is a wrong entry.
provision. Lordship, Assam fixation of ceiling on land holding.
Hmm.
এটুকু করতে পারবেন। $56.
Section,
Section 4. May I read, Lordship? Notwithstanding anything to the contrary to any law, custom or agreed to agreement, no person shall be entitled to hold as honor or tenant land which exceed the limit of 50 bighas in the aggregate, and limit of 50 bighas shall be applicable to aggregate of the land held individually by the members of a family or jointly by some or all members of such family. My lord, the definition of the member that has been lordship given in section 3D. Section 3D, lordship got it.
one or more of the husband.
Family means a family consisting of one or more of the following: husband, wife, minor children, and also includes a joint family. Explanation, your lordship will see. Joint family means family of which the members are dependent from a common ancestor and have a common mess, and shall include wife, husband, or as the case may be, but shall exclude married daughter, married sons, and their children.
They were married sons.
Yes, lordship. That was at that time they were having children.
Therefore, it's not a family.
Yes,
Though they were the sons of Suklal.
yes.
They cannot be included in the.
Cannot be involved. That is my
So
guess.
Suklal had their own 92 whatever.
Yes.
Suklal had how much? 37.
No, it will 92 minus lordship 25.
Hmm.
That will be the total area of land, and beyond 50 bigha that will be taken as ceiling surplus land.
Separately.
So from 92 bigha lordship, 25 bigha of land should be excluded.
Yes, what do you say?
Lordship, let me file the detailed affidavit.
Of course, they have filed the revision in 1976. What is the provision of filing revision?
Lordship is section 6. No, lordship. Yeah. My lord, that is
There is appeal.
7 subsection 6, sub rule
Huh?
subsection 6, 7, section 7 subsection 7, 6,
Subsection?
6. Without prejudice to any action under any other provision of this act, the state government may on its own motion or an application, if filed within a period of 1 year from the date of application of the final statement under so and so, the on which the Assam fixation of ceiling land so and so shall come into force, whichever is later call for any record relating to any final statement and may pass such order as it may fit after giving the person or person.
Hmm. So it was 76, you filed in 78,
I love 70.
should be within 1 year.
Well, that can be lordship. Yeah, that,
Where's your revision, revision?
well, that.
Where's your revision?
Revision lordship only, that is given 1978.
Where is that?
Revision, well, revision is
1978, my lord. Revision number 113.
59, that is reflected.
Where is your revision petition?
Well, a revision petition is not on record lordship. These present petitioner lordship, they were not aware about the ceiling, about this land, because they were continuously, they were in continuous possession.
Yes.
In this regard, whether it is in possession or not,
Page 52 is given, their report.
we have instruction, this is recorded as Sorkari lordship.
Huh?
As per the land record, it is government
No,
land.
that is, they have challenged. Of course, they have challenged after more than 1 year.
Let me file details affidavit, lordship.
What? How you'll improve?
But it is from the record, it is seen in the year 1976 it was made. Thereafter lordship, they have to file the record, take the record lordship.
Let them come with their details affidavit, because affidavit will require in this case. I think for find a better adjudication lordship.
I have the different view. Affidavit, what different, how will improve in the affidavit? Facts remain that it was made surplus in 1976. You file a revision petition, 1978,
My lord,
right?
my lord.
We're supposed to file within 1 year.
There may be reason lordship because they were not.
Yes. It is you to establish that it was condoned or it can be
My lord,
condoned.
let
even
them
if
fi-
after
let
the
them file
expiry
a
of
bit-
1
let-
year.
Let
right?
them file affidavit, we will reply on that.
Hey, first you have to establish. You don't depend on their reply.
My lord, there may be reason lordship because they were not aware, and that explanation is given in the.
Anyway, heard Mr. M. Khan,
Lordship,
learned counsel for the petitioner. Petitioners.
petitioners.
The learned
DC Musahari,
Muslim learned state, what is this?
STBTC.
SC
Council
BTC. By placing the communication dated 26/11/2025 from the Joint Secretary BTC submits that the land measuring 25 biga 0 kata 15 nature, which the petitioner stated to have been recorded public mutilated in favor of two sons of the Nitai Chandra Das and late Gaur Chandra Das, within bracket predecessors of the present petitioner, is a bracket for, which was covered by, which is covered by DAG number 14 of PP number 29 of village block Puti under Moja Ripu number 1 of Gosaigaon, Revenue Circle, Gosaigaon, was made selling surplus land on 09/09/1972 Therefore, the land now is recorded as Sarkari. As per the records, Mr. He submits that he may be allowed to bring on record such facts by an affidavit. Next minute, Mr. Khan, then counsel to the petitioner has also agreed that let the state, that the respondents to bring on such instruction, bring on the instruction by an affidavit. In view of the, let this matter be listed after 4 weeks, 4 weeks.
3 weeks.
So as to enable the learned standing council BTC to file affidavit bringing on record the instruction obtained by him. This after 4 weeks.
Can it be 3 weeks, Lordship?
Huh?
Your Lordship.
Yes.
In this case, my lord, forest department, my lord, a similar method listed before Justice Mojumdar, my lord,
Ah,
and that they took time 2 weeks for filing affidavit.
ah.
So, my lord, it may be, though they are not there,
Okay,
let it come after 2 weeks, my lord.
only prayer of Mr. S. Kotoki, learned counsel for the petitioner. List this matter after 2 weeks, along with
Along with, my lord,
WPC.
6 WBC 619025.
6190/2020.
Lordship, in this case, I am appearing for the contempt number 1, Lordship. I am praying for delay accommodation today, next
Why?
week or day after. Lordship.
What is this?
Regarding demarcation was report
Huh.
of
My problem,
Why IA?
I,
It's filed by me, your lordship. Lordship, I am the contempt number 2 and 3.
Hmm.
But however, we are not on notice, because notice was not issued to us. We were actually affected by if there is a fresh demarcation and then certain things were actually prayed for. And there was also an IA filed by the petitioner side. So and in response to that, we had.
Who are you?
Who are you? I'm actually, the thing is that it is a plot of land which belongs to a family. I am one of the brothers, a brother and the brother's son, and they are one of the brothers. So it is actually there should be a partition in this property, which has not taken place, and lot of disputes. There are multiple of,
That's
no.
why I don't understand why IA.
IA was because we wanted this, give me the copy.
IA is for what?
Actually, we were affected because, your lordship, what had happened in this case is that there was an order passed by this honorable court, and pursuant to that order, the demarcation had taken place. Demarcation, it was categorically mentioned, that was order dated 29 July, 27 July 2024. If your lordship can, in the IA itself, I have.
Lordship, in the order, Lordship, the minutes of the demarcation report was asked for. So today my line of training,
Minutes, yes, your
your
lordship.
content number was to produce that.
No, I just
Yes.
wanted to, I will grant them time, but then
The IA part. So your lordship, if your
the
lordship.
demarcation has already
Taken place. Now, once it is taken place, I have nothing to, but it is just that if I do not want to, as of now,
If demarcation has already been taken.
yes, your
As per
lordship,
the direction of this court.
yes, your lordship.
IA is for what?
Your lordship, if the demarcation, I am actually in favor of this, the demarcation, as far as the report is concerned, I am okay right now. I have nothing to say.
Then
It was-
better ends there.
But right now, I don't want to, I want this IA to be there till the time the matter is disposed of. Because what they are
No,
asking,
no, suppose
your lordship.
only or rightly there is an order of this.
Yes, your
You
lordship.
are agree by that. If you are agreed by other, you file an
Yes,
appeal or
yes,
file.
Your lordship, that is,
Review.
your lordship,
So,
that is what I
appeal.
wanted to,
But by IA, we cannot change that.
Yes.
lordship, that is what I want.
But you are saying that that order has been passed without hearing you,
Lordship,
which affects you.
If I may explain, your lordship, on 27th of July 2024, this honorable court has passed an order where demarcation was given. So thereafter that went on, and then demarcation took place. So the petitioner side came back saying that they want a modification of the order. After that modification, thereafter they filed the contempt case against contender number 1, saying demarcation had not taken place. So this honorable
That is
court
not
passed
correct.
another order, which is dated now 29/7/2025,
Which you are agreed.
which I was aggrieved by. That is when I had come in. But this matter was argued by, yes, your lord.
So if you are agreed by that order,
Yes.
either it will be a review or an appeal.
Lordship, I was actually
The ma-
aggrieved, as in if there was an issue of a fresh demarcation, and I would have been aggrieved if boundary walls were created. Now boundary walls did not get created in this. It was marked. It was just boundary walls did not get, and this matter was argued by. Actually, I was being argued. It was argued by senior advocate Digonto Das in this matter. And then
In my side-
after all the submissions were given, it was decided, this honorable court again passed an order saying let the demarcation happen and let the minutes of the meeting and the office report
That is-
be submitted. Today it is fixed for that. So once that report is seen by this honorable court, and that thing, after that the
We'll
matter
see,
can rest.
he has sought for a time.
You will wait,
grant
we will
it.
wait, your lord.
Why IA? That's what I'm saying.
IA was already argued actually by Digonto. It will be better if senior
IA
advocate Digonto Das only argues the matter again.
Already matter was
See, if you are agreed by the order, whether it is a contempt or writ petition, whatever, either it will be a case for review or the
Your lordship, actually what has happened,
one that it should be modified.
no, your lordship, what had happened is that I was not this IA prayer for it was
Let
not
him-
had
let
happened.
him-
Let it come when the matter is listed, your lord.
Necessary, you are troubling unnecessary papers in IA.
Yes.
Your lordship,
IA
let the matter,
IA is crying. Why I've been unnecessarily been filed?
your lordship, actually what was happening, the things that were being, prayed for in the
Consider-
recalling or,
IA is crying, literally.
no, your
IA
lordship,
is crying that he has been unnecessarily harassed, putting him in the cell.
sorry, your lordship.
This interrogatory application is crying, literally.
Your lordship, what?
It has been filed unnecessary.
Unnecessary.
Your lordship, actually, I was being affected.
Trying to tell that there's nothing, if you are agreed, you have to, but anyway,
Yes.
if you want, you will remain. so.
Yes, your lordship, let this I be.
Because I believe that unnecessary applications should not be
Your
kept.
lordship, I was affected. I live in the premises, your lordship.
That
That is
is
my,
there. You
I
are
live in the
affected.
premises.
If you are affected by any order, what is the review?
Lordship,
I'm saying,
because
of
I,
course.
lordship,
Either you
my,
file a review,
and I understand.
or you file a review or file an appeal, that's all.
Lordship,
If appeal lies, if appeal doesn't lie, it may be a case of review.
Yes.
We just cannot modify the order
Yes.
passed.
Yes.
lordship, there was no modification as I asked for. It
Not
was
by-
only the status quo, the previous
Not
status
by
quo.
dispatch. not-
Passed by dispatch, the previous status quo, the order passed by dispatch. That is, so
That
right
is
now
already
it has
heard.
now come back.
IA was,
Then
I
you
was
make
heard.
it
I has been heard.
Review.
Lordship, but IA has been heard. It has been argued actually by.
MS so and so, learn counsel for the petitioner.
I'm, my senior counsel MK Chaudhary is there in this case, Lordship.
Whose name has to be recorded?
MK Chaudhary.
He's not before us.
I know, yes. Lordship.
Appearing for MK Chaudhary, huh?
Yes.
And MS so and so.
Uh,
For
P. Barua. P. Barua.
respondents, huh? P. Barua
Barua.
for SP Barua.
No, P. Barua. P.
Barua
P. Pallavi Barua.
oblique respondent.
I'm 2 and 3. Respond 2 and 3 here.
Applicant in IA so and so, huh? And respondent number 2
2.
in
In
contempt
the
petition,
contempt petition.
not in the writ petition.
In the writ petition, I was 5.
He was a- he
I was
a-
5.
5 in
5 in the writ petition.
next para. As on the prayer of Mr.
H. Sharma.
H. Learned Counsel, appearing on behalf of Alice Contemnant number
Sorry,
one.
that's one number.
That this matter be listed after 3 weeks.
No, Lordship, the next Thursday, because matter is urgent for us.
What
Because of the demarcation is not done, I
After 2
cannot
weeks.
take possession of my property.
Madam,
That is,
2 weeks.
uh,
Madam, 2 weeks.
no, I shall be out of station, Lordship, that's
Then
why.
after 3 weeks.
No, no, Lordship, that, then vacation will come.
Then
Matter is
ma-
urgent
no
for us,
matter.
Lordship, that's why today it was fixed, Lordship. Because without demarcation, I cannot take possession of
See,
my,
which
my
today,
share.
this is fixed for the IA, for contempt or what?
Contempt, your lordship.
Contempt, not I was
Not
already
IA,
ha-
contempt.
So honorable
Contempt.
court has directed him to produce the minutes of this
Then
demarcation.
Thursday will close
The
the.
next Thursday, Lordship,
There is a direction to demarcate.
Yes.
They have demarcated what lies
let
there.
it produce, Lordship,
Yes.
next Thursday, Lordship, no
Thursday.
problem.
Huh? 4 December.
4th December.
Yes.
My problem is this, Lordship, the chamber is under renovation. The files are piled up like this because of that, I'm unable to trace it out. But even then, Lordship, I will try my level best on Thursday.
It's a contempt. You'll have to take it
Contempt,
seriously.
contempt.
Lordship, I appreciate. Much.